Well, up next is Deborah Struhsacker. And Deborah is a hard rock mining policy expert with over 30 years of hands-on expertise with the environmental and public laws and regulations governing mineral exploration and mine development. Deborah and two other Reno-based geologists started the Women's Mining Coalition to lobby Congress against changes to the U.S. mining law and has actively participated in this decades-long legislative debate. Deborah was one of 15 women featured in the National Mining Hall of Fame and museum exhibit entitled Pioneering the Field, Women in Mining. Deborah has a master's degree in geology from the University of Montana. Please welcome Deborah.
Well, good morning. Appreciate the opportunity to be here today, and I'm going to kind of take up where Mike left off with the cheery news to talk about the Rosemont lawsuit and a related lawsuit involving the Thacker Pass lithium project in Nevada. And I'll just begin my presentation by saying what Rosemont and Thacker Pass represent are anti-mining plaintiffs' attempts to use the judicial system to change the mining law and to achieve what they have not been able to achieve, thankfully, yet, to change the mining law by persuading Congress to enact a bill that would essentially gut the mining law. So we're recognizing how difficult it is to get a bill passed in Congress. We're seeing anti-mining factions try to use other branches of the federal government, in this case the court system, but we're also seeing it in the administrative system with changes in regulations, which is not my topic today, but just understand that the mining is pretty well under assault from many angles, as Mr. Vincent discussed earlier today. Okay. So I'm going to start by giving you an overview of the two deposits that are in question in these two lawsuits, because ultimately the geology of these deposits, and I think in answer to a couple of the questions that were just asked of Mike, the geology at a given ore deposit is going to define the best approach to trying to address the outfall or the fallout from the Rosemont litigation. So Rosemont is located about 30 miles southeast of Tucson, Arizona, and it is in a well-established mining district. It is a large porphyry copper and skarn deposit. The host rocks there are steeply dipping Paleozoic metamorphosed limestones, and the ore is comprised of both sulfide and oxide zones. Curiously, in the plan of operations that was submitted to the Forest Service, and this was the Coronado National Forest, that plan of operations to develop the mine did not include ongoing exploration. It was just a mining plan of operations, which is kind of unusual if you think about it. The administrative record for the Rosemont case in plain black and white very explicitly states that there is no evidence of valuable mineral deposits discovered on the waste dump land. So that is the fact that the court had to use. Whether or not, how many are geologists here? I mean, it's in a big porphyry copper system, it's kind of hard to say, oh, there's no mineralization over there. But that is what the record that the court had in front of it, that they were compelled to use to decide this case. The administrative record went on to say there is undisputed evidence showing no valuable minerals have been discovered on the mining claims for the waste rocks and tailings areas. And there were no mill sites involved in this project. The entirety of the project footprint for all the mine waste management facilities were on unpatented load claims. Shifting gears to Thacker Pass, Thacker Pass is located 20 miles northwest of Orovada, Nevada. It's in the McDermott Caldera, which is a Miocene feature, and it's near the Nevada-Oregon border. It is a lithium claystone deposit. It is formed in intracaldera lacustrine sedimentary host rocks that contain lithium-rich clays. It is an extensive tabular flat-lying deposit that covers thousands of acres. Its configuration is kind of like a coal seam. Ongoing exploration was definitely a part of that plan of operations. There was something like 150 acres of surface disturbance that was devoted to mineral exploration. The administrative record in Thacker Pass, very much in contrast to the administrative record at Rosemont, at Thacker Pass, that record says there are potentially valuable lithium mineral deposits valuable lithium mineralization throughout the project area. And in responding to a district court's remand order, BLM's response found evidence of mineralization on all but 8 claims in the waste rock and tailings facilities areas. But like Rosemont, Thacker Pass did not involve any mill sites. It only involved unpatented lode claims. So the Thacker Pass litigation is an outgrowth of the Rosemont litigation, and here are the mining law issues that are at stake at Thacker Pass and by inference Rosemont. So at Thacker Pass, the plaintiffs assert that the Ninth Circuit's 2022 Rosemont ruling applies to Thacker Pass and that the claims to be used for mining waste facilities must be mineralized. So in February of 2023, a U.S. District Court for the District of Nevada remands the EIS that BLM did for the Thacker Pass project, and it directs the BLM to evaluate whether claims proposed for the waste rock and tailings facilities are mineralized. And very notably, the court did not vacate the BLM's decision, record of decision to approve the Thacker Pass project. It instead remanded the decision back to the BLM to take a closer look at the mineralization status of the lands that were going to be used for waste rock disposal. In May 2023, so almost exactly a year ago, the Nevada BLM responds to that remand order and prepares a lengthy, it's about 100-page long geologic report that finds that on the basis of exploration done to date, drill hole data, and geologic inference, all but 8 claims have evidence of mineralization. So that's that kind of little d discovery standard that Mike was mentioning earlier that BLM in Nevada has applied to the Thacker Pass project in response to Rosemont and the Thacker Pass litigation. That remand order response also says that the project proponent has a couple of options for those 8 claims where there is not yet discovery of mineralization. They could be converted to mill sites, or the facilities could be reconfigured to avoid those 8 claims, or there could be additional exploration done that could potentially prove there is mineralization. But the BLM was very specific that a claim validity exam was not necessary or applicable, and the BLM headquarters office then issues that solicitor's opinion that Mike just described that says, well, you got to prove a discovery, but you don't have to do a mineral validity exam. And so that's how all of this evolved at Thacker Pass. Then in July of 2023, the Ninth Circuit Court of Appeals affirms the district court's ruling and upholds BLM's approval of Thacker Pass. So here are the mining law issues that are raised in both the Rosemont and the Thacker Pass cases. First of all, does Section 22 of the mining law authorize the long-term occupancy of public lands for ancillary facilities? Must lands used for long-term occupancy contain a valuable mineral deposit? Are Section 22 mining law rights restricted to claims that are being explored and claims with the discovery of a valuable mineral deposit? Can federal land managers use their surface management regulations for locatable minerals to authorize ancillary facilities on lands without a valuable mineral deposit? So that would mean BLM's 43 CFR 3809 regulations and the Forest Service's 36 CFR 228A regulations. Finally, must federal land managers use discretionary regulations like a right-of-way or a special use permit to authorize ancillary facilities on lands without a valuable mineral deposit? So those are the questions framed by these two lawsuits. So here's what the court found regarding Section 22. This is what the Court of Appeals found for Rosemont. It said, if no valuable minerals have been found on the land, Section 22 gives no right of occupation beyond the temporary occupation inherent in exploration. And a right of occupancy lasts only so long as there are valuable minerals on the claim. That lasts only until the claim is worked out or until economic forces make it no longer profitable to continue mining. Thacker Pass, which had to follow the circuit court's decision in Rosemont, says, the mining law treats exploration and occupation for purposes of mining differently. The Rosemont court found that Section 22 required a discovery of valuable minerals before a project proponent could permanently occupy any land, including with waste dumps or tailings piles. And the court finds, that was bound by Rosemont, that BLM must determine whether Lithium Nevada, that's the project proponent at Thacker Pass, has valid rights under the mining law to occupy the 1,300 acres for waste rock dumps and tailings. The Thacker Pass court went on to say that the Rosemont court explains the mining law allows the owner of a valid mining claim on land containing valuable minerals to obtain possessory rights to other lands for use as mill sites. And Mike mentioned mill sites in his presentation. And regulations specify that mill sites can be used for waste dump and tailings piles. So here's what the courts are saying about Section 42. Again, returning to the circuit court here, Rosemont wants to occupy 2,447 acres with waste rock, even though no valuable minerals have been found and no mill sites have been established. But the circuit court found the mining law anticipated this very problem that Rosemont faces. Finding a place to dump its waste rocks, the mining law allows mill sites on non-mineral land. Dumping waste rocks is permissible on mining lands on which valuable minerals have not been discovered. And I think that's a tremendously important thing to understand about the Ninth Circuit's Rosemont decision, which is that court sought to make the mining law work. That court, which I'll just say kind of editorially, perhaps unlike the district court in Arizona that made the unfavorable decision on Rosemont in the first place, the Ninth Circuit tried to come up with a way to make the mining law work so that miners can use mineralized lands for their mine, obviously, and they can explore for minerals on unpatented mining claims. They can't use them for permanent waste rock disposal, but you can use a mill site for that. So it all works. The Thacker Pass court cites something similar, and it says that the Rosemont court found a distinction in the mining law between exploration and occupation that forms a key plank of its analysis. So here's kind of the crux of the matter as I see it. As I mentioned earlier, plaintiffs in these two cases are trying to make the mining law not work. And they're trying to say that the only way you can use lands under the mining law is if those lands contain a valuable discovery. And they are asserting that there is a gap in the mining law. And in fact, the plaintiff's attorney in the circuit court arguments at Thacker Pass actually said that the mining law only authorizes half a mine, just the mining part of a plan of operations. And they kind of tried to ignore Section 42 of the mining law that authorizes locating mill sites on non-mineralized lands. So the court is trying to make the mining law work while plaintiffs are trying to tear it apart. And I'll note that basically what the plaintiffs have done here is that they have relied on a couple of the solicitor's opinions that Mike mentioned earlier, dating as far back as 1997 to the solicitor's opinion pertaining to mill sites, and then later on to ancillary uses, saying that you can only use mining claims for lands with a mineral discovery. That mill site opinion, the 1997 mill site opinion, says limits the number of mill sites that you can use. So again, the Ninth Circuit Court's Rosemont opinion confirms that the mining law authorizes all mining activities and ancillary uses. There is no gap in the law. So I'm going to kind of fast forward here in the interest of time, and I'm going to come up with some suggestions for how we navigate the situation in a post-Rosemont and Thacker Pass landscape. So I mentioned earlier that geology, I think, is going to make the determinant of the best way to address this at any given project. So having said that, there is no one-size-fits-all prescription or blueprint because every mining project has unique geology. The appropriate configuration and combination of mining claims and mill sites must be based on each project's site-specific geology and the locations for the proposed mine facilities. You'll recall that the administrative record at Rosemont says that the lands proposed for mine waste storage facilities are non-mineral, period, full stop, no questions. Thacker Pass administrative record, in great contrast, however, says there is suggestion of widespread mineralization. So I'll suggest to you that we'll call it head frame exploration during mining may discover mineralized areas that can expand the mine and determine some areas that do not contain minerals economic to develop. Facility layouts and mining claim and mill site configurations can be adjusted in response to evolving information. And of course, heaped on top of that is fluctuating commodity prices will determine ore versus waste and may influence the mining claim and mill site configuration. I think the geology sections of NEPA are going to take elevated importance going forward. I mean, heck, I'm a geologist, and I have to tell you, most of the time when I would read an EIS or even an EA for a mining project, I would kind of breeze through the geology section, yeah, because that's not usually what was the focus of the analysis. But I think that has changed. And I think now the geology sections of the affected environment chapters in NEPA documents need to be really carefully written to show that lands that are mineral in character or where geologic inference could be used to imply there are minerals is where mining claims are warranted. And lands that are still being explored are also a place where mining claims are warranted because future exploration may discover minerals. And if I were you, I would never call something a condemnation drill hole ever again. That drill holes are drill holes, and the purpose of drill hole is to discover minerals. And oftentimes we as geologists don't get lucky and we don't discover minerals, but that's all a process of mineral exploration. And if you do have lands where the geology clearly shows that they are non-mineral, yes, it may be appropriate to locate mill sites. Keeping in mind that mill sites are a snapshot in time, because what's mineral today may not be mineral tomorrow or vice versa. I mean, there have to be a whole bunch of open pit mines these days that have waste rocks piled up around their perimeters based on mine shells that were drawn at $1,000 an ounce gold that would have a really different pit shell today at approaching $2,400 an ounce gold. So I'm going to conclude here pretty quickly, but mining and mineral exploration take a long time. This is a really cool graphic from showing the history of discoveries of a number of mineral deposits in Nevada, in the Carlin Trend and in the Cortez pipeline trends. And the takeaways from this graph here are that back in the 1940s through the 1980s, most of the discoveries that were being made were pretty shallow. But starting in the 1990s or so, mines in Nevada started discovering underground mineralization, or I should say mineralization that was economic to mine as an underground mine. Most of those discoveries were made by collaring shafts or exploration declines or adits in the base or side of a pit. And today in Nevada, many of our mines are being developed as underground mines, many of which started out as surface mines. So there's an evolution of discovery here that takes, well, here you see a period of 60 years. And as you know, Mike implied in one of his statements, gosh, have they never heard of an underground mine? So yeah, you might have nothing on the surface, but certainly mineralization underground, that's got to be a mining claim in order to secure those mineral rights. This is a cross-section of the pipeline area in the Cortez District in Nevada, and the takeaway here is that the Gold Rush deposit, which is a multi-million ounce deposit that is just starting to be mined by Nevada Gold Mines. It's going to be mined at about 400,000 ounces a year, really major discovery, really high grade on the order of about 10 grams per ton. It's a huge discovery that took about 2 decades to actually delineate. You'll see from the surface here, this area looks like a pincushion with the number of holes that have been drilled into it. It takes a long time to make discoveries like this that are deeply buried. So miners have to have security of land tenure throughout that duration of exploration in order to be able to make these discoveries. And that's what Section 22 of the mining law provides, and that's why having unpatented mining claims on a deposit like this throughout the duration of that exploration period is necessary to secure your rights. You can see also there's a deeper deposit there called 4 Miles. 4 Mile is still in the development stage. It is a monster. It's Nevada Gold Mines is predicting that it may have a mine life of up to 40 years. Gold Rush has a mine life of about 26 years, and they've known about them for a long time, but it's taken a long time and tens of millions of dollars to discover them. So just very quickly, there's a bill that just passed in the House last week called the Mining Regulatory Clarity Act that seeks to undo the confusion that the Rosemont litigation has created and clarifies that restores rights under the mining law that Rosemont throws into question. So that bill has passed out of the House. It has not yet advanced out of the Senate. There's one other issue that is sort of hanging out there. There's litigation in the Circuit D.C. Court of Appeals, Earthworks versus DOI. In this case, Earthworks, the plaintiffs are trying to assert that Leshy's 1997 solicitor's opinion that limits the number of mill sites you can use is the law of the land. We're all on pins and needles waiting to hear how the Court of Appeals decides that decision. So long as they deny the plaintiffs' assertions then we've got the mill site solution that the Ninth Circuit Court has offered us in Rosemont. And with that, I appreciate your attention, and I'd be happy to answer any questions that you have.
Yeah, have either of these decisions brought any further guidance on the definition of a mill site? And what is that definition in the current mining law?
Current mining law, in Section 42 of the mining law, says a mill site is non-mineralized and non-contiguous, and that it is limited in size to 5 acres. And Mike, have I missed anything? And non-contiguous. Well, to a geologist, I'm going to say that in most mining districts, it has very little meaning because there's just mineralization in lots of places. I mean, gosh, you have a porphyry copper system. That's a huge hydrothermal system with a huge mineral footprint. Thacker Pass, you have this laterally continuous section of lithium-rich clays. I mean, it's going to be defined on a site-by-site, geology-by-geology basis. But given where commodity prices are going and the potential that most mines, gosh, they start out with a limited mine life and ongoing exploration continues to discover more mineralization, the concept of non-mineral is a little hard to get your hands around, I'd say, in most mining districts.
I have a question about the patent process, which I think was under the Clinton administration by administrative rule, disallowed. You can locate a claim, but you can't patent it anymore. What about that as a vehicle, is to be able to basically get the surface rights or mineral rights deeded?
Well, unfortunately, in 1993, Congress placed a moratorium on patenting, and that moratorium is still in effect. So it is no longer, we can no longer patent mining claims. And there's Congress could change that, and pigs could fly, because I think that is an obvious solution. And you might ask, well, once the mine is there, why does the public want that hole in the ground back? But I just think the politics of the situation are such that reinstating patenting as part of the mining law is unlikely, unfortunately.
But that was the key thread that unraveled this whole thing, because as you go in through patentship, it does become private land, and that's where you dispose of your waste at, through the patentship process, and that transfer from public land into private ownership. Then that is where mining companies have historically deposited their wastes and their tailings, because it is private ownership at that point. As the mine continues to expand and you lift the bathtub edge and you start to encroach on new unpatented areas, now you're in this situation as what do you do going forward?
It certainly complicates matters, although not all mines, and even older mines, patented all of their claims where the waste rocks are. But it is a solution that is no longer available to us, unfortunately.
For Thacker Pass, could they mine the lithium layer, the seam out, and then that would no longer be a mineralized area, and they could call that a mill site in one claim at a time, and just?
Well, I mean, you raise an interesting question. Once the minerals are gone, can it still be a mining claim? Potentially, if there's still, maybe lower grade mineralization that you could get from it, or mineralization underneath. But they could, I suppose they could use a mill site. The the decision for Thacker Pass was not problematic for them. So they were able to reconfigure their facilities a bit. The 8 claims in question, they did not need to occupy with mine waste management facilities for quite a long time in the future, so they have time to be able to either prove it, continue to show there's mineralization on those claims with more exploration, or potentially locate mill sites on them, or just not use them at all.
One last question.
It's more of an observation that regarding patenting, that was directly political. The decision to do away with patenting, which was in continuing resolution, was in an Appropriations Act, and that's continued on each year. But in regard to why that ban was put in there, it was because of that charge that the environmentalists had made that we're selling land for $5 an acre. And so that was a direct response to that. Well, we can't have that. We can't have mining companies buying it for $5 an acre. Also, in regard to mill sites and mineral in character, I guess it's important to define mineral in character under the law. It's actually a definition that's about the same as for discovery, only inference is involved. You can infer whether or not there might be minerals there of a value that could result in a paying mine. So there is a standard there in case law that defines mineral in character, and mill sites are just not that. So.
Well, I want to thank you for your attention, and I want to apologize. I have to leave. I've got to catch a plane. This is a terrific conference, and I really appreciate the opportunity to be here today.